Are you McKaylin Jones?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Jones, in cause number 22-39715, I have a motion to revoke your,
I'm sorry, just
Oh, that's okay.
we're only going to count 2, 3, and 4 whenever you get to it.
thank you.
That is correct. Thank you, Mr. Wood.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the offense of possession of a controlled substance, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
And it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of flight from an officer May 17th of 2023 in parish of Point Coupe in Louisiana. And is that true or not true?
Yes, ma'am.
True or not true? Thank you. Count 3 alleges that you committed the offense of illegally carrying of a weapon May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
And then count 4 alleges that you committed the offense of possession of a Schedule I drug on May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Judge, if I may, the motion was filed in June of 2023 based on offenses that happened in May of 2023. He's been in Louisiana custody since those offense dates of May of 2023. However, our hold for this motion to revoke didn't get placed on him until October 7th of 2024.
And Judge, Mr. Rojas, I'm sorry to interrupt, Mr. Rojas, and I have conferred, the state is not opposed to the court giving the defendant the credit for the time he's been in jail while this case is pending. You may recall, I've researched the issue. I actually briefed it and I gave the court that authority.
You did.
I think you have that authority if you choose to award him that credit.
Okay, so what I'm thinking I would do, I'm not going to go back to the offense date. I think the cleaner way to do it is to go to the date of the motion,
Okay.
which is just a month or so
Right.
or less. But I think that at least for our purposes, if somebody's looking at it, they'll see motion was filed on that date, warrant was issued, but there wasn't a hold place for some reason.
Correct.
And so I'm going to allow credit from June 7th of 2023. In whatever time that adds up to, I will, we'll get that done. Okay?
Thank you, Judge.
All right, so Mr. Jones, I am handing you the trial court certification. Well, 2 things. One, showing that this was an agreement, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and thank you, probation, for being here as well. Okay, Mr. Rojas, you have Crystal Moore. House numbers 23 DCCR 2026 and 25 DCCR 0496.
Should just be a bond holding under
There's a motion
2026.
for bond and then a response filed by the state.
I needed to see this before, let's see. Yeah, it looks like it. No, that's okay. I see, which is fine.
That's mine.
Good morning, you're Crystal Moore. All right, y'all give me just a second to, got there a couple things here.
See what?
He either happens or it doesn't happen.
So are you asking for, I know so there's a motion to revoke probation in 23 DCCR 2026, and there's no bond set in that one, correct?
Correct.
And then in 25 DCCR 0496,
I think there's a $6,000 bond in there.
I showed $2,000.
well,
Take two.
That's what I showed.
can y'all help me figure out that real quick with the actual bond? I know you're not asking for that one to be reduced.
No, Judge.
So really, we're just talking about the other one
The
anyway.
motion to revoke.
Okay, so on probation for DWI with a child passenger, and the new offense is theft, correct? State jail felony?
That's correct, Your Honor. And there's also a case that was, she was arrested for possession of controlled substance that has not been filed yet.
Okay, probably waiting on labs on that?
Yes, ma'am.
Okay, and that same date as the theft, or is that something different? Do you know?
I don't have anything.
Okay,
October of 24 is what my notes indicate.
And this was December of 24.
Well, I'm a little confused. I've got an October theft, and I also have a November theft, according to my summary of her criminal history. Both of them are listed.
Our indictment shows that the offense date of December 26, 24.
I'm not sure, Judge.
okay, that's okay. So I want to make sure, and Mr. Coleman has filed a response, and part of that response includes the information that Ms. Moore was previously convicted of the offense of robbery, initially placed on a deferred probation that was revoked in 2017 on that case. Also a conviction for aggravated assault out of Tarrant County from 2016. And then we've got the probation that was granted here on the driving while intoxicated with a child passenger. Let me get this pulled up again real quick. And while on this probation has been arrested for two new offenses, the theft and the possession of a controlled substance. Is that?
That's correct, Judge. And since you got my motion, or my reply, you've already read it. I'll just be brief. I just want to add that according to my recitation of her criminal history, it looks like she's got a total of 5 pending cases that include an unauthorized entry of an inhabited dwelling out of Louisiana.
I see that as well. And there, do you know if there's warrants issued for those? I know it's hard to get information. Do you know anything about those?
No, Judge, this is the first I'm hearing about that when I saw that in the motion. I don't know if there's any holds on her from Louisiana or not.
All right. Mr. Rojas, do you wish to call any witnesses?
Briefly, Judge, I'll call Ms. Moore.
Ms. Moore, best you can, raise your right hand. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead, Mr. Rojas.
Ms. Moore, where are you from?
Correct.
And have you lived in Port Arthur all your life?
Yes, sir.
All right. Who do you live with when you're not in jail?
My family.
Speak up for us.
My family, my mom.
Okay, and who all lives in the home with your mom?
Me, my mom, and my kids.
Okay, and how many kids do you have?
5.
And what are the range of their ages?
My youngest is 1, and my oldest is 11.
And is your mom taking care of those kids right now?
Yes.
Okay, and my understanding is that your mom is also ill right now?
Yes.
What is the nature of her illness?
She has a brain tumor and has to undergo treatment and surgery.
And is there a surgery scheduled for that already?
Well, she actually postponed it due to she has no support with my kids right now.
Is she the only adult in the home with your kids?
Yes.
All right. And that's one of the reasons you want to get out, to make a bond in this case, so that you can go out and take care of your kids, make arrangements for them, because your mom's going to have some surgery and she won't be able to do it anymore.
Yes.
All right. Do you have any income when you're not in jail? Do you have any income coming to the home for you?
Yes.
What do you have?
SSI and child support.
SSI, how much do you get in SSI benefits?
1,000.
Is it every month?
Yes.
And child support, how much do you get?
140
How often is that?
every 2 weeks.
140 every 2 weeks, so that's $280 a month there. Do you have a bank account in your name?
Yes.
Do you have an idea of how much money's in the account right now?
Probably like 500.
Do you own any property that you could sell to help you come up with money for this bond?
Yes.
Is your mother or any other family members, are they willing to help you come up with money to make the bond if the judge has set a bond for you?
My mom, she can proceed with her procedure.
Your mom's willing to help you out?
Mhm.
Okay. And that's what you're asking the court to do this morning, set a bond on the motion to revoke on this DWR, right? And the main reason for that is so that you can get out and help your mom take care of her kids and get her past the surgery.
Yeah, like I understand that in the future I might have to serve time for my actions, but that's like my goal was to get out so she could undergo treatment and I could fully prepare her and my kids so when I do have to serve time.
Okay, pass the witness.
I have no questions for this defendant, Judge. I stand on the motion. I don't have anything to add to the motion. If the court's inclined to grant this defendant a bond, I just simply ask you to consider the factors listed in that motion, Judge.
Well, I'm looking back just for everyone, for the record, at the pre-sentence report that was prepared in cause number 23, 2026, and I've reviewed that. I've also reviewed, there's a handful of jail incident reports that everyone was given a copy of as well. Based on the nature of Ms. Moore's prior convictions, which range from, give me just a second to go back through this. Beginning as a juvenile, back in 06, 07, extending all the way through 2012 as a juvenile, assaults, thefts, violation of court orders, and then we get into adult, and we've got more thefts, county jail, theft of property, then we get into felony, we've got a robbery, given a probation, that was revoked, we've got a theft from a person, and then we've got an aggravated assault with a deadly weapon, that one from Tarrant County. Now on probation, given all the opportunities, multiple allegations in the motion to revoke probation, that Ms. Moore has not apparently done much of anything while on probation to get the help that we've been offering her. In addition to having two new offenses, a possession and another theft, I find that it is in the best interest of our community that there not be a bond set in cause number 23 DCCR 2026. I appreciate the arguments and I feel and have empathy for what your mom is going through, but you should have thought about that before you kept doing what you were doing. So you can go back with the bailiff. I'll set the case for an announcement on the motion and the community. Good morning, sir. Are you Rontez Williams? And Ms. Holmes, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Williams, in cause number 22-40090, you're charged with a third-degree felony offense of fraudulent use of identifying information from January 20th of 2022. And how do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them. Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up.
Yes.
She has to hear you too over here, all right? They're just taking everything down. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes, all right? Good luck to you, sir. You can go back with the bailiff. Was that one the one that just left? Okay. Good morning. Are you Terry Rose?
Yes, ma'am.
And Mr. Rose, in cause number 24-1369, is charged with the offense of murder. There was a request for a competency evaluation that was done by Dr. Rapon. I'm going to take judicial notice of the court's file. We've received that evaluation dated May 23rd of 2025. Dr. Rapon, after that evaluation, makes the finding that Mr. Rose is currently competent to stand trial. Is there any other evidence with regard to competency? Mr. Burbank?
Defense, Judge. No, Your Honor.
Then at this time, I am going to find that Mr. Rose is competent to stand trial. Mr. Burbank, announcement?
Your Honor, as you are well aware, I'm the second one.
Right.
I just need one more announcement, 30 days or 40 days, and we may be able to.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor, we're just, state's ready to proceed.
And I appreciate you getting up to speed as quickly as possible. Looks like we've got an investigator involved and you've taken care of that.
We do,
So,
and I was out, I provided him information, and he's helping me with this, and so once I cover all my bases and get up to see the district attorney, we'll be able to take care of this matter.
all right. What I'll do to make sure your investigator and you have plenty of time to get up to speed is reset it 45 days and expect. All right.
State's ready, as far as I'm aware, from Mr. Coleman, Judge. I would ask that Mr. LeBlanc make a request for the media if he has not done so already, since we have plenty of time in between.
Okay. Have you asked for and received the media?
I believe this is the one, yes, I've asked for it, but I haven't received it. I think I have a, I'll have to check if I have it about all this, but
It's
at any rate.
okay.
Ready.
Well, but if your client hasn't seen the videos or any type of media with you, then how do you know for certain that this is what is the appropriate end game? Because he hasn't seen, I would assume in an assault on a peace officer, there's body cam footage that might affect what agreement there is. Do you know if that is, can that get ready today?
Yes, Judge, it doesn't look like it was marked as requested and received, but I can follow up on it.
I want that done today.
Yes, sir.
I want you out to see Mr. Fleming's by tomorrow
Yes, sir.
to review that with him, and I want to know by tomorrow at noon that it has been done and that in fact this is what Mr. Fleming's wants to do, is go to trial after seeing that. All right? I want to hear from you at noon tomorrow. Okay. Put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalvius Williams. And Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that that was true. And do you want to continue to plead true to that count?
Yes, ma'am.
Okay. And then count 2 alleges that you're behind in your court assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count?
Yes, ma'am.
You want to change your plea to not true?
Yes, ma'am.
Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses, Judge.
Okay.
They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
Knocking on the front door. So we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's
Yes.
it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion, and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that?
Yes, ma'am.
Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options.
In this courtroom session, every case underscored the importance of accountability and the legal process. Some defendants acknowledged probation violations and accepted the court's decisions, while others faced new allegations that required careful judicial review. Throughout the hearing, the judge examined plea agreements, case records, and the evidence presented before issuing each ruling. Whether addressing probation violations, bond requests, or negotiated resolutions, Every decision reflected the court's responsibility to balance fairness, due process, and public safety. These proceedings demonstrate that every choice carries legal consequences, and each ruling represents an important step in ensuring justice is applied through the rule of law.